Hello and thank you for choosing to watch this webinar. In this webinar I'm going to talk to you about good complaint handling. The reality is that no matter how much you strive to provide an excellent standard of service, it's unlikely that you will avoid complaints completely. It's therefore vital that you handle the complaints well. As you'll know, you have a regulatory requirement to have a procedure in place for handling complaints that you receive about the service you provide. Your clients also need to be informed at the time of engagement about their right to complain to you, how they go about doing this, and also their right to bring any unresolved complaints to us. As I said, it's highly unlikely you'll ever avoid complaints entirely, and as such it's really important that you make the process of complaining as straightforward as possible for those who feel the need to raise an issue with you. So firstly, I want to talk about recognising when a complaint is being made. Sounds straightforward, doesn't it? But it isn't always that easy. It's really important that you and all of your staff within your business know how to differentiate between that client who's raising a query and a client who's raising a concern that should be addressed under your formal complaints handling procedure. Your client won't always know to ask you to commence your procedure, and sometimes you might need to ask if that's actually something that they want. Our scheme rules define a complaint as being an expression of dissatisfaction. Although we do encourage people who come to us in the first instance to consider making their complaint in writing, it's important to note that a complaint doesn't have to be in writing to be considered as an expression of dissatisfaction. There's a difference between a customer raising a query and making a complaint. If in doubt, it's better to ask. Ask them whether they're wanting to make a complaint and whether they'd like it to be dealt with under your complaint handling procedure. It's also worth thinking about whether, if I was a client and I phoned your firm today, would the first person I spoke to know how to respond if I wanted to complain, or even if I just sounded like I might be complaining? Think about who it is that I'm likely to speak to when I call. Are you confident that they know how to respond to a complaint being made? Do your fee earners know how to respond to the grumbles that a client may be making? Do they also know when and how to escalate those grumbles if they haven't gone away? These are things that we find can catch service providers out. We quite often get cases where it's clear to us that a client has been raising an issue with their fee earner, but that's gone unaddressed. And if 8 weeks has passed, then they can come straight to us, meaning that you've lost out on your opportunity to resolve it first throughout your own complaint handling procedure. Thinking about the complaint process then. So once you know you've got a complaint, do you take the time to make sure you really understand what is being complained about? There's no point trying to resolve something if you're picking up on the wrong points. Once you've received a complaint, it's important to acknowledge it. Say that you're dealing with the complaint and give yourself a reasonable period of time to investigate. We all know that it's better to sometimes be a little cautious with your timescales and then over-deliver if necessary. Next, it's really important to be clear in your response what you've investigated, what you've found out, and to say whether or not you think that the standard that's been provided was reasonable. Of course, if you found that it wasn't, also say what you intend to do to try and resolve that. Finally, don't forget to signpost. I'll talk about that in more detail in a short while, but we so often see firms who don't resolve complaints within 8 weeks and don't signpost to the legal ombudsman properly. Also, it's worth saying that the process doesn't end with the final response. So think about whether there's anything you can learn from or improve on going forward. If you routinely see a lot of complaints in similar areas, does this mean you can improve things going forward in that particular area? Thinking then about what a good complaint response looks like. Now, language used in handling complaints can have a significant impact on the outcome. Service providers increase their chances of resolving matters at first tier if they respond formally and professionally, if they use terms that are easy to understand, also if they reassure customers. So perhaps you would reassure them that you'll investigate their complaint fully, but they won't be charged for that. Also, really key, apologise where it's needed. Don't be afraid to apologise if it's a genuine apology because something has gone wrong. Customers' experiences of complaining to legal service providers are usually overshadowed by a feeling that the provider has already behaved poorly towards them. Therefore, they've reported to us feeling that the likelihood that their complaint will be received or handled well is low. This can sometimes be complicated by the reluctance to revisit a stressful event and a desire to just put the whole thing to bed and move on. If something is serious enough for somebody to complain, it's serious enough to warrant a substantive response. The more comprehensive that response is, the more likely it is to be accepted. Now, comprehensive doesn't need to mean chapter and verse. You don't need to write 12 pages to make a decent first-tier complaint response. However, you can and absolutely should be clear about what you've looked at, what you've found, whether you think it was poor service or not, and why. Simple changes in the language you use can make customers feel listened to and understood. Once they are assured that you know why they are complaining and why the matter is so important to them, they're more likely to feel that you've reviewed the matter fully and fairly. When it comes to complaint responses, one of the issues we see is the tone of letters and the language that's used. Complaints can feel really personal both to the individual who's provided the service and to maybe the firm or the business. We can often see that in the way that a response is written. Sometimes the responses we see can feel very argumentative or defensive. It's brilliant if you're litigating a case, but we'd suggest it's not the right tone to be using when you're trying to resolve a complaint. More positive letters don't necessarily have to agree with consumers' points of view, but the language that they use is much more conciliatory. They do acknowledge when something goes wrong and they do apologise where necessary. So we would suggest really having a think and having a look at the tone and the language that you're using in your complaint responses. A helpful tip is to read the letter from the client's perspective. Would the tone really encourage resolution, or is it more likely to provoke a negative response? It's also important to remember to remain courteous throughout the entire complaints process. You're not going to resolve complaints if the way that you're writing to an individual appears to be rude or defensive. Okay, so let's now have a look at a couple of genuine complaint responses. I've highlighted this example as a good response example. It says, "I'm very sorry that, on this occasion, our service did not meet your expectations. Feedback is very important to us as a company, and I appreciate the time you have taken to bring this to my attention. I have reviewed the file, and you are correct that there was a lack of regular updates between the file creation on 10th of August 2017 and 18th of October 2017. I do apologise for this lack of updates, and I acknowledge that this may have caused you some frustration. Please be assured, however, that this did not in any way hinder the progression of your transaction, and all work was progressed as soon as was possible. Nevertheless, this is not the standard of service I would have expected us to provide, and for this I apologise. I must balance this with the fact that you did not request an update during this time, or contact us to let us know that you were feeling frustrated. In the circumstances, whilst I do not consider that a remedy is appropriate in this matter, I would like to confirm that I have provided feedback to the staff involved, and going forward we are looking into sending automated updates on cases where there has been little progress." So there are a couple of things I really like in this complaint response. Firstly, we're leading with a sorry. Now, I know that can make us feel a little squeaky. It's not a word you like to say in complaints handling. It may even be one that you're actively encouraged to avoid. However, "I'm sorry that our service did not meet your expectations." That's not an admission, that's a fact. The client has said that they expected one thing and they received another. As a normal human person, that makes us grumpy. You can be sorry that someone feels a certain way without admitting any wrongdoing. So here the person feels let down. You can acknowledge that without admitting that you've done any wrong. It also makes sure to acknowledge that feedback is a good thing. This helps us to improve. Yes, being complained about is never nice, but it is an opportunity to learn. The complaint response here acknowledges that the issues raised, it was a valid one. It doesn't just say this happened and this happened there were some periods of delay. It says, do you know what? You're right. It explains why there's not a remedy directed to the complainant, but it doesn't end there. Having started by saying feedback is important to us and then finding some failings, it also tells the client what's going to be done about it. Having looked at a good response, now let's have a look at one that's not quite so good. Again, I'll just read this one to you. So it says, when I undertake a complaint investigation, I do so using my extensive experience in the profession to reach the correct decision. You emailed us on 12th of September asking for an update. Given we'd only been instructed for 3 weeks, your expectation here were unrealistic. You have queried the fees, and I am therefore attaching your signed terms and conditions letter for your further information. You will note that all of the fees are listed at clause 8. I can confirm that no refund is due to you, nor are there any grounds for a complaint. If you wish to escalate this matter to the legal ombudsman, we are fully prepared to defend ourselves. This is taken from an actual complaint response from a conveyancing firm. It starts off by assuring the reader that they've reached the right decision. So how could it possibly be wrong? Also, if the complainant's expectations were unrealistic, whose fault is that? How were they to know they were unrealistic? Was there any management of those expectations when the matter started? For me, simply reattaching documents and saying, well, you signed it, doesn't actually explain the investigation that's taken place. And saying that there are no grounds for complaint is just going to cause that person to be upset that you have dismissed their complaint. And then this use of language at the end, we are prepared to defend ourselves. Why do we need to be so adversarial there, so argumentative? I do want to say as well, when I was looking through cases to find examples, I was filtering by cases where the complaints handling wasn't reasonable. And in such a large number of these cases, the reason that we were saying it wasn't reasonable because there was simply no response at all. We do appreciate that service providers can be dealing with hundreds of files and it's easy to miss things, but failing to identify and respond to complaints, that's then meant that you've lost all chance to try and resolve it without our involvement. In addition to this, you're pretty much guaranteeing that you'll be charged a case fee. So please just make sure you allow some time for yourself to respond to any complaints that you receive. The final point I wanted to make in this webinar is vital when it comes to how you handle your complaints. That's the fact that signposting your clients to the legal ombudsman is a regulatory requirement. The legal ombudsman released jointly commissioned research with the Solicitors Regulation Authority, which indicated that clients were still not routinely being made aware of their right to complain about poor service by lawyers, despite the regulatory obligation to signpost clients to the scheme. In addition to this, it's also good practice. It makes sure clients are fully aware of their options and provides a degree of finality to the complaints process. It's also important to understand that the legal ombudsman will only accept complaints brought to us within 6 months of your final response. However, for this to take effect, the final response must do this signposting piece. So it must say that it's a final response, and it must direct that client to the legal ombudsman and make them aware of the 6-month rule. Without these elements, the rule will not come into effect. Also, in terms of our timescales generally, we accept complaints about acts or omissions which happened in the last 6 years. If it falls outside of that time, we can still accept it, provided the client only became aware of the issue within the last 3 years. So just for me now to say thank you very much for watching this webinar. If you'd like to see other webinars, please have a look on our website for webinars on our business process, how to prevent complaints, and how we determine complaints. Thank you. Goodbye.